You'll forgive me, I do not have slides reflecting the fact that I've been around for so long. I should point out that the New York City Criminal Justice Agency is a direct descendant of the original Vera Institute Bail Reform Project. I make that point because it means that we and the criminal courts in the city of New York have had well over 40 years of experience dealing with this issue of release on recognizance and dealing with risk assessment-based recommendations to the court. I think that's important because in many instances, I think we are fundamentally dealing with court cultures that take a long time to develop and an equally long time to change. And so the information I will give you now about New York City should be understood in that context. Been about the business a long time. As the pretrial agency, we interview, I've also got a bit of a cold, you'll forgive me. We interview everybody who is arrested and held for custody or held in custody pending initial appearance, which is the criminal court arraignment. And all cases begin in the criminal court and are arraigned there. Last year, that meant we interviewed approximately 285,000 cases. So it's a big job. It also means that we have an enormous information base on virtually all of the arrests that are made in New York City, whether they're custodial arrests or citation arrests. And we're able to track them until the case is ultimately disposed and, if convicted, the sentence that is imposed on that. Since in many ways our mission is to reduce detention and to reduce the use of money bail, we have a particular interest in determining who gets bail set and what happens. And as a result, we have in fact done a good deal of research on that issue in New York City, and it's basically some of the highlights of that research that I will report to you today. Those highlights have been taken from a fairly extensive report entitled A Decade of Bail Research in New York City by Dr. Mary Phillips, who's our Deputy Research Director, and you can get it commercial on our website, www.nycja.org. One of the peculiar things in New York State, peculiar these days, is that the statute defines the purpose of bail as making a decision to assure the defendant's appearance in court. That means that contrary to most states, our statutes do not authorize the court to consider directly the risk to public safety posed by the defendant if the defendant is released. And so for that reason, the risk assessment instrument that we use focuses only on the risk of failing to appear. In New York, if a defendant is charged with a misdemeanor or lesser severity offense, he can plead at that initial appearance, at the arraignment. The case can be disposed, a penalty can be assessed, and the case is essentially over with. And in fact, well over 60% of those cases charging a misdemeanor or violation are in fact disposed at criminal court arraignment. On the other hand, all of the felonies cannot be disposed in criminal court. They must go to the higher court, so they are continued. And then the other misdemeanors and violations that do not plead are also continued. What happens with them? Those cases that are continued, last year, 68% of those cases were released on recognizance. And so I think another thing that fairly distinguishes New York City is we have a very, very high rate of release on recognizance. And that's generally true of felony cases as well as misdemeanor cases. And those, in the meantime, the rest of the cases, bail is set, and a relatively small percentage of those cases will make bail at criminal court arraignment. In fact, about 11%. Some will make bail as the disposition process continues, but ultimately about 44% of the felony cases in which bail is set at criminal court arraignment will remain detained until the case is disposed. And about 47%, believe it or not, of the misdemeanor cases or the non-felony cases in which bail is set will remain detained until the case is disposed. That, of course, would mean that in many of those, the disposition comes fairly quickly, but nonetheless, they are detained for at least several days. CJA's research sought to determine whether the fact of a defendant being detained influenced the likelihood of conviction, and if conviction, the likelihood of an incarcerative sentence. You've heard earlier research which pursued the same issue. And we came to essentially the same conclusion. We found that detention definitely increased the likelihood of conviction and the likelihood of incarceration after a range of other factors, such as the seriousness of the charge and the defendant's criminal history, were taken into consideration. Importantly, we noted as well that the effect was stronger in felony cases than in misdemeanor cases. So if nothing else, that adds to the growing amount of research that indicates that what happens pre-trial affects almost everything. Our research then also sought to identify factors that influence the judicial decision to either release or to impose bail at criminal court arraignment. And again, after a range of factors were tested in multivariate models, the single strongest influence was found to be the prosecutor's bail request at arraignment. The research also determined that the prosecutor's bail request was largely determined on charge severity and criminal history. This despite the fact that, at least according to the statute, the critical issue to be decided by the court is the risk of flight. We then sought to determine whether the prosecutor's bail request was a more effective predictor of a released defendant's failure to appear as compared with our risk-based recommendation of release. And I'm happy to say that our risk-based recommendation won hands down. One of the things I guess that implies is that contrary to the idea of emphasizing only risk of flight, the prosecutor's bail request essentially reflects his or her desire for conviction and the sentence to be imposed upon conviction. So finally, our research then sought to measure the extent to which commercial bail bondsmen were involved in cases in which bail was set and made. And we found that they were involved in only 15% of those cases in Manhattan and Brooklyn, which meant that 85% of the cases in which bail was being made it was being made without benefit of a bail bondsman. It was being made by the defendant and by his family and friends that would come to the fore. We also found that where bail bondsmen were involved, they tended to be involved in the high bail amount cases because that's where the profit can be made. And they were rarely, if ever, participants in cases in which the bail amount was set at $1,000 or less. So, at least in New York City, bail bondsmen are of no help whatsoever to poor people who are being held on low bails and often on low severity charges. Thus, the influence of the commercial bail bond industry in New York City, I can't say this for the rest of the state because I don't know, but certainly in New York City, the influence of the industry appears to be considerably less than it is in other jurisdictions around the country. And that raises the question, how come? Why is that the case? I think the answer probably rests in On the one hand, the state, by statute, limits the amount of money that a bail bondsman can charge in various cases. And that undoubtedly has an effect. But the other reason, I think, is again, getting into the court culture. Bails, when they are set in New York City, tend to be relatively low as compared with other jurisdictions around the country. So, for example, last year, in felony cases in which bail was set, the median bail was only $5,000. And in misdemeanor or lesser severity cases, the median was only $1,000. I think that's an important point because there is often in our field a good deal of discussion about how to move away from bail. It would certainly suggest that legislation is appropriate and helpful, but also culture. Again, it takes quite a while. So it's clear that the judges in the criminal courts in the city of New York are on the bench with a tendency leaning toward release and release under the least restrictive alternatives. So there's a considerable more information in that report that I referenced and a considerably greater amount of research regarding a whole range of criminal justice topics on our website. I invite you to use it. Thank you.